Nature of Indian Constitution. Nature of Indian Constitution. See, in the world, constitutions, some of them are called unitary and some of them are called federal. Some constitutions are called unitary constitutions and some constitutions are called federal constitutions. What do you mean by unitary constitution? Unitary constitution means when all powers are centralized in one government, that is the central government, that is called unitary constitution. When all powers are centralized in one government, that is called central government, then that type of constitution is called unitary constitution. In the unitary constitution, states act like mere small units, subordinate bodies. They do not have any particular specific great powers. States do not enjoy autonomy in unitary setup. When the constitutions are made in favor of completely center, the states will have only limited powers. The best example for unitary form of government is Britain, UK. The best example for unitary form of government is Britain, that is UK. Whereas some constitutions are called federal constitutions. F-E-D-E-R-A-L, federal. Federal means there is a division of powers between central government and state governments. Division of powers between center and states. This is called federal. The best example for federal is USA. American Constitution is the best example for federal setup. American Constitution is the best example. You know why? In America you have dual citizenship. We have citizenship for the USA and states will also have their own citizenship. In America, states can have their own constitution. States can have their own flags. States can have their own set of laws. So America is a typical model of federalism. So UK is a model for unitary constitution. America is a model for federal constitution. Now there is a question. What about Indian constitution? Is it federal? Is it unitary? There is a question. What about Indian constitution? Is it federal model or is it unitary model? The answer is many experts have defined Indian constitution in their own way. Many experts, constitutional experts, define Indian constitution in their own way. For example, Professor K.C. Ware, W-H-E-A-R-E, Professor K.C. Ware defined Indian constitution as a quasi-federal constitution, Q-U-A-S-I. Professor K.C. Ware defined Indian constitution as a quasi-federal constitution. What do you mean by this quasi-federal? It looks like federal. It appears like federal, but it is not truly federal. It looks like federal, it appears like federal, but it is not truly federal. This is called quasi. The constitution, the working of the political system appears like federal setup, but India is not a truly federal state, according to Professor K.C. Ware. According to Professor Ivor Jennings, I-V-O-R-J-E-N-N-I-N-G-S, according to Professor Ivor Jennings, India is a federation with a strong centralizing tendency. According to Professor Ivor Jennings, India is a federation with a strong centralizing tendency. That means India is a federation, but it heavily has a centralizing tendency. According to Glanville Austin, G-L-A-N-V-I-L-L-E, according to Glanville Austin, A-U-S-T-I-N, Indian federalism is a cooperative federalism. according to Glanville Austin, Indian federalism is a cooperative federalism, and when something comes from the horse mouth, we generally give more validity to it. When something comes from the horse mouth, we generally give more preference to it. When B.R. Ambedkar speaks on Indian Constitution, we generally rely on that definition, right? When B.R. Ambedkar speaks about Indian Constitution, we generally give more validity to his statement. B.R. Ambedkar said, Professor B.R. Ambedkar, Dr. B.R. Ambedkar also was a professor. He said, he was the chairman of drafting committee of the Indian Constitution. B.R. Ambedkar was the chairman of drafting committee of the Indian Constitution. He said, notwithstanding many provisions in the Indian Constitution, which are deviating from federalism, still Indian Constitution is a federal constitution. What do you mean by that? He said, see, there are many provisions in Indian Constitution which are not federal, but still we can call India as a federal constitution. This is the definition of B.R. Ambedkar, Dr. B.R. Ambedkar. And you should remember a fact here. The word federal is not mentioned in the Indian Constitution. It was not defined by the Constitution. The word federal do not have a mention in the Indian Constitution. Article 1 of the Indian Constitution says, India that is Bharat shall be a union of states. They have not named India as federal country in Article 1. They said India that is Bharat shall be a union of states. So, a debate comes whether Indian Constitution is a federal constitution or not. There is a very big debate whether Indian Constitution is a federal constitution or not. In this debate, to conclude whether India is a federal country or not, first of all you should know what are the important features of federalism. The very important feature of federalism is division of powers. The first important feature of federalism is division of powers. There should be a proper demarcation of sphere or domain of central government and state government, because in the matters of national interest, where holistic policy is needed, center will have the power. In the matters of local interest, regional interest, state will have the power. So this is called division of powers. Does Indian Constitution have division of powers? Yes. In our Constitution we have 7th schedule. In that 7th schedule we have lists. Union list, state list, concurrent list. In the union list, center can make the law. In the state list, state can make the law. In the concurrent list, both center and state can make the law. So, 7th schedule deals with list, division of powers between center and states. So, the first important feature of a federal country, federal governance, is division of powers between center and states. Some students generally write separation of powers. This is a wrong word. You should use division of powers or distribution of powers. Division of powers or distribution of powers. Don't generally use the word separation of powers. In Constitution, generally the word separation of powers is used for legislature, executive, judiciary. In the organs of the government, how we have to separate the powers. But division of powers or distribution of powers, center and states are local governments. Okay. So first is division of powers or distribution of powers. The second feature is almost all the federal constitutions, general statement, it's a generalized statement, will have a written constitution, WRITTEN, written constitution means the constitution will have a script. It can be showed or produced like a document. For example, America have a written constitution, India had a written constitution, whereas Great Britain's constitution is mostly unwritten. India has a written constitution, America has a written constitution, whereas British constitution is mostly an unwritten constitution. Okay. First statement is distribution of powers. Second is other symptom is written constitution. Other characteristic is written constitution. The next important characteristic is rigid constitution. RIGID. Rigid constitution. What do you mean by this rigid constitution? Rigid constitution means it is difficult to amend the constitution. Rigidity means difficult to amend. Difficult to amend. For example, American Constitution is a rigid constitution. American Constitution is a rigid constitution. Okay. And Indian Constitution, with respect to important provisions affecting states, it is rigid. With respect to unimportant provisions, it is flexible. It is flexible. Okay. So, why rigid constitution is a feature of federalism? Because if changing of the constitution is in the hands of the central government or the state government exclusively, they will keep on changing the constitution in their own favor. So, for that reason, constitution should be very, very rigid. Generally, neither the central government nor the state government are supreme, but it is the constitution which is the supreme law of the land, which both the central government and state government should follow. Both the central government and state government should follow the constitution, which is also called as the supreme law of the land. So, first is distribution of powers. Second is written constitution. Third is rigid constitution. Fourth is constitution is the supreme law of the land. And the fifth is supremacy of the courts. Supremacy of the court, COURT courts. That means whenever a dispute arises between center and states, the court should take a final call. The judiciary should take a final call. The authority lies with the courts. For example, in India, according to Article 131 of the Indian Constitution, the Supreme Court had original jurisdiction. In India, according to Article 131 of the Indian Constitution, the Supreme Court had original jurisdiction. Whenever there is a dispute between center and states, or between center and some states on the one side and all the states on the other side, or two or more states, any issue with respect to federalism, the Supreme Court, according to Article 131, deals with that. So, all these features India also have. All these basic features of federalism India also have. Then why debate? Why discussion? Why we have doubt? Why debate? Why discussion? Why we have doubt? The reason is there are some provisions in the Indian Constitution which are deviating from federalism. There are some provisions in the Indian Constitution which are deviating from federalism. There are some provisions that you should know first. See, if you see Article 3 of the Indian Constitution, Article 3 speaks about establishing, particularly naming, renaming or alteration or formation of new states. Formation of new states. Article 3 says, see, Telangana was formed based on Article 3 of the Indian Constitution. Telangana was formed based on Article 3. The state governments or state legislatures' opinion about formation of new state or alteration, all these things are only, they have only very less negligible importance. The central legislature, that is the parliament, will take a final call over the creation of new state, alteration of the boundaries of existing state, etc. For that reason, the very existence of state is at the mercy of the central government. That is the central legislature. The very existence of state is at the mercy of the parliament. Okay, whether the state has to exist, whether the state have to be rebordered or boundaries should be changed, or whether the state should be bifurcated, all these things, the final call will be taken by the central government. Article 3 deals with this formation of new state. Don't get confused between Article 2 and Article 3. Article 2 deals with admission of new states. Article 3, admission means, for example, Sikkim have become the new state into India. Earlier it was ruled by Namgyal dynasty. Whereas Article 3, formation of states within India. So India is called as indestructible union of destructible states. Indestructible union of destructible states. So this is what is. The first thing is, according to Article 3, the Parliament will alter the boundaries or establish a new state within India, and the states do not have that power. Number 2, other important aspect of why India is not called a strict federal country, why India cannot be said as a strict federal country. According to Article 153, 154, 155, particularly according to Article 155, appointment of governor. Article 155 deals with appointment of governor. See, the governor is neither directly elected nor indirectly elected. The governor is neither directly elected nor indirectly elected. He was an appointee of the center to the state. President will appoint him to the state. The post of governor, according to Article 55, appointment is made, and there is no mandatory rule that the chief minister should be consulted before appointment of the governor to the state, except to the state of Jammu Kashmir. This is also a deviation from federalism. First deviation is alteration of boundaries or formation of new states. Second deviation is post of governor. And whenever I am explaining a thing, I am also giving an example from article from the Indian Constitution. While writing polity answers, you have to definitely mention articles. So when you are writing about renaming the state or establishing a new state, Article 3. Whenever you are writing about appointment of governor, Article 155. In the same way, next deviation is emergency provisions. Article 352 to 360. Article 352 to 360 of the Indian Constitution deals with emergency provisions. There are 3 types of emergencies. In all the 3 types, when emergency is declared, India will work like unitary model. The entire country will transform like unitary model. Or when, for example, when a state emergency is declared under Article 356, the center will have a bigger role in the state. So in any kind of emergency, it looks like unitary model. So this is one more deviation. And next deviation is, if you see, Article 248, residuary powers. According to Article 248, the powers which are not in the state list or concurrent list, whether they are in the union list or not, the powers which are not mentioned in the state list or concurrent list, whether they are in the union list or not, completely goes to the central government, center, parliament. See, generally in federations, residuary powers lies with the states. For example, America. The powers which are not in the union list, the powers which are not in the state list or concurrent list, whether they are in the union list or not, whether they are in the union list or not, they come under residuary powers. We have borrowed this having idea of residuary powers to the center from Canadian model. Even this is deviation, Article 248. In the same way, according to Article 249, if Rajya Sabha, that is Council of States, passes a resolution with a 2/3 majority present and voting that on national interest, Parliament can make law in the state list, then Parliament can make law in the state list. According to Article 249, if Rajya Sabha passes a resolution that Parliament can make law in the state list, then Parliament can make law in the state list. For all these reasons, many constitutional experts say that India is not a strict federation. India is not a proper federal country. But here you should understand a point. We call America as United States of America. The reason is, states have come together and formed American Union, United States of America. Whereas in India, the states were integrated. When we got independence, we have around 562 princely states. They were integrated with lot of difficulty. So, much preference was not given to the states with respect to destructions, formation, all these things. That does not mean that India is not a federation. See, we have modeled our own federation to meet our own circumstances. India has stitched its own model of federalism without losing the concept of national integrity and nation's progress and the unity of India. With respect to Indian historical and specific circumstances, we have had our own model of federalism. We cannot say America is federal, India is not federal, because what is good for America might not be good for India. What is good for America might not be good for India. So, India is a federation to meet its own specific needs. There might be some deviations from federalism. The deviations are made only to maintain the integrity and unity of the nation. By seeing the deviations, we cannot say India is not a federal country. So, India is a federation with its own uniqueness and safeguards. This is the answer, nature of Indian Constitution. Pin to pin, exactly, you have to replicate this answer. The format should be the same. You can use your own terminology, but the format, the structure should be the same. Is India a federal constitution? Is India a federal setup? Okay, coming back again. Next topic, sources of Indian Constitution. Sources of Indian Constitution. How Indian Constitution is made? What are the various sources of Indian Constitution? Here, there is a very famous statement about Indian Constitution. Indian Constitution is a bag of borrowings. Indian Constitution is a bag of borrowings. We have borrowed many things for the Indian Constitution. So, this is the aspect which is very, very important. Traditionally, this question of sources of Indian Constitution is a match the following question. But for mains, when you are writing an answer on fundamental rights, for example, you can say, we have borrowed the idea of fundamental rights from American Constitution. Or whenever you are writing about judicial review, you can say, in America, Marbury versus Madison is the first case where judicial review was applied. Or when you are writing about parliamentary form of government, we have inspired by British setup to have parliamentary form of government, like that. So, you should all know with full strength that the sources of Indian Constitution is very, very important for the exam. In fact, this is a base question, a question which is really base for polity. Sources of Indian Constitution. So, first of all, you should know what we have borrowed from Government of India Act 1935. Government of India Act 1935. Listen. Government of India Act 1935 is like a base to our constitution. Before independence, if you consider all the documents, the lengthiest document is Government of India Act 1935. It consists of 321 sections and 10 schedules. It consists of 321 sections and 10 schedules. And first you should remember, an all India federation idea. Before Government of India Act 1935, India worked like unitary model. You all know that British ruled India. British government is unitary government. Before 1935 Act, India was like unitary model. By 1935 Act, new idea called federation, all India federation. The concept of all India federation we brought from Government of India Act 1935. In the same way, Britishers brought the idea of governor's post. In the provinces, at that time states are called province. Madras province, Bombay province, United province. So like that we call them as provinces. The head of the province is called governor. So the same model of governor almost we have borrowed from Government of India Act 1935 to the new constitution. In the same way, emergency provisions. Generally students write emergency provisions we have borrowed from Germany. It is wrong. Emergency provisions we have borrowed from Government of India Act 1935. Suspension of fundamental rights during emergency, German Constitution. Weimar Constitution, Germany. Weimar, W-I-M-A-R. Weimar Constitution, Germany, we have borrowed suspension of fundamental rights during emergency. Whereas emergency provisions as such we have borrowed from Government of India Act 1935. And the list, like union list, state list, exclusively concurrent list we have borrowed from Australian Constitution. But generally the idea of having list we have borrowed from Government of India Act 1935. Even the post of speaker which we have today, Britishers had that post of speaker in their parliament, in their lower house. In the same way we also have speaker's post which was created in Government of India Act 1935. Similarly we are following the post of speaker even today. You all know speaker for Lok Sabha, speaker for state legislative assembly. And next is British Constitution. What all we have borrowed from British Constitution? See, the exam which you are writing, civil services exam, this entire civil service exam model basically from ICS exam. Before independence it is called Indian Civil Services. And remember, Britain used to follow merit system for civil services. In America earlier, not now, they used to follow a system called spoils system. In America earlier, they used to follow a system called spoils system. Means whenever new president comes, he used to appoint his own people with his own ideology in the bureaucracy. Whereas in Britain they used to follow merit and logic. They used to conduct a very competitive exam called civil services exam. So we have borrowed the idea of civils from Britain. And from Britain we have borrowed parliamentary form of government. You know that we have parliament, bicameral legislature, all these concepts from Britain. And we also have borrowed lawmaking procedure. You all know the passing of the bill. It should be introduced in one house, it should be passed in one house, it should go to other house. This entire model of passing of the bill we have borrowed from British Constitution. We have also borrowed the idea of single citizenship. You know, in America we have double citizenship, whereas in India we have single citizenship. Actually single citizenship model is unitary model, double citizenship model is a federal model. India had unitary model called single citizenship. Even that you can write in the unitary features in the Indian Constitution. So how India is deviating from federalism? India is having single citizenship. Where from you have borrowed the single citizenship? From Great Britain. This idea of single citizenship from Great Britain. And we also have the concept called parliamentary privileges. Parliamentary privileges. See Article 105 and 194. Article 105 for Parliament, 194 for state legislatures. The parliamentary privileges concept we have borrowed from British model. In fact, before 44th Amendment 1978, we used to have the word House of Commons there. After that we have removed. Indian parliamentarians will enjoy the same privileges as the House of Commons parliamentarians enjoy. The members of House of Commons enjoy. But we have removed this House of Commons by 44th Amendment 1978. So even this we have borrowed from British model, parliamentary privileges. And from Britain we have taken a concept called rule of law. Be you ever so high, the law is above you. Be you ever so high, the law is above you. A.V. Dicey. A.V. Dicey. So even this concept, though the word rule of law do not find place in the Indian Constitution, the spirit of rule of law is found in right to equality, Article 14 to 18. So we have borrowed this concept of rule of law from A.V. Dicey, D-I-C-E-Y, from Britain. Next, from American Constitution what we have borrowed? See, in America fundamental rights are called Bill of Rights. Americans were the first to give constitutional status to fundamental rights. Americans were the first to give constitutional status to fundamental rights. India also have given constitutional status to fundamental rights. And we have elaborate list of fundamental rights in Part 3 of the Indian Constitution, Article 12 to Article 35. Elaborate list of fundamental rights in Part 3 of the Constitution, Article 12 to Article 35. This idea of having constitutional status to fundamental rights we have borrowed from American Constitution. From America we also had a very good important thing, that is independence of judiciary and judicial review. Independence of judiciary and judicial review. In Indian Constitution we don't have the word judicial review, but according to Article 13, the laws which are against fundamental rights are void. So Article 13 impliedly gives power to the judiciary to review the laws which are against fundamental rights. Judicial review is borrowed from America. Independence of judiciary is borrowed from America. And procedure for the removal of Supreme Court judges. In the Indian Constitution, Article 124 deals with procedure for removal also. Even this process we have borrowed from America. And you all know that Indian President is a part of legislature, part of executive. American President is only a part of executive. American President is the supreme commander of the armed forces. Namesake, nominally, Indian President is also supreme commander of the armed forces. Nominally, Indian President is also supreme commander of the armed forces. Even this we have borrowed from American Constitution. Next is Canadian Constitution. What we have borrowed from Canada. See, Indian Constitution and Canadian Constitution are called as twin constitution. They are called as twins. India and Canada are called as twins. You know why? Almost they resemble each other. Almost they resemble each other. You know twins? Twins generally resemble each other. Indian Constitution and Canadian Constitution resemble each other. And one more fantastic thing. We have basic structure theory in our judicial evolved doctrine, right? Now we are reading. The word basic structure theory is not mentioned in the Constitution. It was evolved in a case called Keshavananda Bharati. It was evolved in the case called Keshavananda Bharati. And you should also know, even in Canada, there was a judicial evolved doctrine called basic structure theory. Even in Canada, there is basic structure theory. And coming back, federation with a strong center. India is a federation with a strong center. Canada is a federation with a strong center. India is a federation with a strong center. Canada is a federation with a strong center. This federation with a strong center has been taken from Canadian Constitution. Residuary powers. Generally in federations, residuary powers lies with the states. Whereas in India, residuary powers lies with the center. This concept also we have taken from Canadian Constitution. Even in Canada, residuary powers lies with the center. Residuary powers lies with the center. And one more important thing, you all know that Canada is also ruled by Britain. Even in Canada, they have similar parliamentary form of government like India. So all these things shows that India and Canada almost have similar constitutions. Next is Irish Constitution. Constitution of Ireland. The most important thing you all know, part 4 of the Indian Constitution deals with directive principles. After fundamental rights, next chapter is directive principles. The difference between fundamental right and directive principle is fundamental rights are enforceable in court of law, directive principles are not enforceable in court of law. The idea of having directive principles we have borrowed from Irish Constitution. Ireland borrowed it from Spain. The idea of having directive principles from we have borrowed from Irish Constitution, Constitution of Ireland. And you know that we nominate 12 members to Rajya Sabha. Literature, Science, Art, Social Service. President of India nominates 12 members to Rajya Sabha. Nomination of members to Rajya Sabha we have borrowed from Irish Constitution. Nomination of members to Rajya Sabha we have borrowed from Irish Constitution. And most importantly, we have a electoral college, proportional representation by means of single transferable vote for the election of president. Procedure for the election of president we have borrowed from Irish Constitution. Procedure for the election of president we have borrowed from Irish Constitution. Apart from that, Australian Constitution. From Australia what we brought? See, what is Article 108? Joint sitting. Article 108, joint sitting. When there is a deadlock over passing over the bill, we can have a joint sitting according to Article 108 of the Indian Constitution. The idea of having two houses sitting together and resolving the deadlock, this concept we have borrowed from Australia. Having joint sitting we have borrowed from Australian Constitution. And concurrent list. Lists, the idea of having list we have borrowed from Government of India Act 1935. But having concurrent list we have borrowed from Australian Constitution. Concurrent list is a list where both central and state can make the law. Concurrent list is a list where both central and state can make the law. And see, India is a very big country, large territory. There are many states. We have 29 states and 7 UTs. Interstate trade commerce intercourse. Interstate trade commerce intercourse. Also we have borrowed from Australian Constitution. Interstate trade commerce intercourse also we have borrowed from Australian Constitution. And we also borrowed the idea of cooperative federalism. The idea of cooperative federalism. Cooperative federalism, central and states should work together. States among themselves should work together. All these things we have borrowed from Australian Constitution. And we also borrowed fundamental duties. See, in the original Constitution we don't have fundamental duties. Part 4A, after directive principles. Part 3, fundamental rights. Part 4, directive principles. Part 4A, fundamental duties. Fundamental duties from Russian Constitution. 1 or 2 textbooks have given that Japanese, but the right answer almost is Russian. Whenever there is a choice of Russian, go with Russian. So, fundamental duties are not there in the original Constitution. They were added to the Constitution by 42nd Amendment 1976. They were added to the Constitution by 42nd Amendment 1976. Fundamental duties are borrowed from Russian Constitution. And in our preamble, you all know that our Constitution starts with preamble. In our preamble, we have the word called justice. Even this idea of justice is also borrowed from Russian Constitution. The idea of justice is also borrowed from Russian Constitution. And French Constitution, you all know there are 3 words which shook the French world, which are the inspiration from French Revolution. There are 3 words which are inspiration for French Revolution. The words are given by Rousseau, R-O-U-S-S-E-A-U, a famous French thinker. The words are given by Rousseau, a famous French thinker. Liberty, equality, fraternity. Liberty, equality and fraternity. In our preamble we have used this word. These 3 words are very, very important because they have borrowed. Also they have borrowed from French. France, liberty, equality, fraternity. And South African Constitution. See, we elect our Rajya Sabha members indirectly. The way how we elect Rajya Sabha members, we borrowed from South African Constitution. Election of Rajya Sabha members, South African Constitution. In Article 368, we have our procedure to amend the Constitution. The way how we have to amend our Constitution, which was written in 368, it was borrowed from South African Constitution. So, procedure for the amendment of the Constitution, election of members to Rajya Sabha. These 2 are the important features which you have borrowed from South African Constitution. Apart from that, Japanese Constitution, procedure established by law. In Article 21 of the Indian Constitution, we use the word procedure established by law. The word procedure established by law have been borrowed from Japanese Constitution. So these are the basic things which are borrowed from other constitutions in the world. Okay, and you know many things about the how Indian Constitution, what are the various provisions of the Indian Constitution by now. These are the basic facts of the Indian Constitution. And one more thing which you have to remember, 26th November is the Constitution Adoption Day. 26th November is the Constitution Adoption Day. Our Constitution came into force on 26th January 1950. Our Constitution came into force on 26th January 1950. And when a question comes, popular sovereignty rests with people. Remember, in India, popular sovereignty rests with people. Legal sovereignty rests. So, coming back again. The most important thing, coming back, the chapter Fundamental Rights. Next chapter. So, shall we take 2 minutes break? I'll have some tea and we'll start again. మీరు చదువుకోండి, మీకు బ్రేక్ కాదు. Part 3. Part 3 of the Indian Constitution deals with fundamental rights. The chapter of fundamental rights is also called as Magna Carta. M-A-G-N-A-C-A-R-T-A. Magna Carta. M-A-G-N-A. Magna C-A-R-T-A. The fundamental rights chapter is also sometimes nicknamed as Magna Carta of the Indian Constitution. Listen, you might get a doubt, where from this idea of fundamental rights actually started? Some thinkers say that the idea of rights emanated from nature. The idea of rights emanated from nature. There was a very big story which some textbooks write about the emanation of rights. When God created the world, according to Bible, God also created Adam and Eve, a man and a woman. And God asked both of them to enjoy everything but not to eat an apple from a particular apple tree. And after God left, Eve provoked Adam and both of them have consumed an apple from the apple tree. If at all God exists, God is omnipotent, omniscient and omnipresent. Why should God call Adam and Eve and ask them why they have done that? Because it's a basic human right. When you are going to punish somebody or when you are going to deliver a judgment, you should listen the other side also. Even this emanated from nature, according to experts. Coming to the modern sense of rights, in 1215 AD, in the year 1215, 1215, in England, King John have given some rights to the people by giving a document. The name of that document is called Magna Carta. The name of that document is called Magna Carta. So, whenever somebody gives some elaborate rights, we used to nickname as Magna Carta. So, this is one thing. Second thing, American Constitution. You all know that American independence 1776. American Constitution is the first constitution in the world which gave constitutional status to fundamental rights, that is Bill of Rights. American Constitution is the first constitution which gave constitutional status to fundamental rights, that is Bill of Rights. And we have French Declaration of Rights of Man. And before our constitution came into force on January 26, 1950, on December 10th, 1948, there is Universal Declaration of Human Rights. United Nations Organization have delivered a declaration called Universal Declaration of Human Rights. And taking inspiration from all, Indian Constitution also have an elaborate list of fundamental rights. Article 12 to Article 35 are in Part 3 of the Indian Constitution. Article 12 to Article 35 are in Part 3 of the Indian Constitution. And first of all, you should remember, as a newcomer to civils, every student will get a doubt. See, if fundamental rights are so great, so sacred, why don't Constitution guarantee 500 fundamental rights or 1000 fundamental rights or at least 100 fundamental rights? Here you should understand a point. Our Constitution was made through the deliberations of Constituent Assembly. When Constituent Assembly sat, as every human being aspired, the members of Constituent Assembly also aspired to give lot many rights to the people. But the issue is, when you promise something as a fundamental right, you have to deliver it. because fundamental rights are justiciable, they are enforceable. If fundamental rights are violated, we can go to court. A citizen can go to court, a person can go to court if fundamental rights are violated. So, with the limited capacity of the state cannot promise each and everything as a fundamental right. Though there are various demands which can be considered for fundamental rights, with the limited capacity, very crucial things which are basic minimum needed for the human beings are considered as fundamental rights. So, we can consider our fundamental rights as 6. Basically, till 44th Amendment Act 1978, till 44th Amendment Act 1978, we have right to property as a fundamental right. Till 44th Amendment 1978, we have right to property as a fundamental right. By 44th Amendment 1978, we have removed fundamental right of right to property. We have made it as a legal right. Now, our fundamental rights were made as 6 total. They are grouped together as 6 fundamental rights. We have now 6 fundamental rights. Okay. Right to equality, right to freedom, right against exploitation, right to freedom of religion. Right, first is, listen, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. First of all, we should know what are the characteristics of fundamental rights. Before going into elaborate discussion on fundamental rights, you should know the characteristics of fundamental rights. What are the features of fundamental rights? First, you should remember, fundamental rights, as the name signifies, they are very, very fundamental, they are very important. If a fundamental right is violated, we can go to Supreme Court or High Courts. You can file a writ petition in Supreme Court under Article 32 and in the High Court under Article 226. If your fundamental right is violated, you can file a writ petition in the Supreme Court under Article 32, in the High Court under Article 226. Second thing, fundamental rights are not absolute. Absolute rights are ruinous to the society. If you grant absolute or uncontrolled rights, the result will be nobody's rights will be protected. No one's rights will be protected. You know why? Your absolute right might harm the rights of your neighbor. Your freedom ends where the tip of my nose starts. Fundamental rights are not absolute. For example, you have fundamental right of freedom of speech and expression. But do you have absolute right to say anything? Do you have the absolute right to paint nude pictures? No. Or do you have absolute right to hurt somebody's sentiments? No. So, fundamental rights are not absolute. They are qualified. They are restricted. For example, Article 19(1)(a), freedom of speech and expression. In the same way, all fundamental rights are available to citizens. But some fundamental rights are not available to non-citizens. See, simple technique. In the article of the Constitution, if they use the word person, that means Indian citizens and foreigners. If they use the word citizen, that article applies only to citizens. For example, take Article 14. The state shall not deny to any person equality before law or equal protection of laws. Here Article 14 applies to persons, including non-citizens. Whereas Article 16, equality of opportunity in public employment. Can an American saying that I can also apply for civils, write the civils exam? No. Only citizens of India have this right. Article 16. So, all fundamental rights are available to Indian citizens. Some of the fundamental rights are not available to non-citizens. Okay. A next important thing. A citizen cannot waive his fundamental right. WAIVE. A citizen cannot say, I don't want my fundamental right. A citizen have no right to waive his fundamental right. You might get a prelims question, can a citizen waive his fundamental right? No. A citizen cannot waive his fundamental right. And other interesting thing about fundamental rights chapter is, many of the statements in the chapter starts with negative statements like the state shall not, no citizen shall, like that. That means fundamental rights imposes restrictions on state action. Fundamental rights impose negative obligations on state, not to interfere, not to interfere, not to do that. And you all know that only once we have added a right. 86th Amendment 2002 added right to education as a fundamental right. Article 21A. The statement starts like, the state shall impose compulsory, free and compulsory education of the children between 6 to 14. This is a positive right. This is a positive right. Okay. State is asked to do something. State is not asked to stop. State is asked to do something. So, for example, 86th Amendment 2002, right to education is a fundamental right. Not to right to higher education. It is right to education between 6 to 14. Right to education between 6 to 14. In the same way, fundamental rights can be suspended during national emergency. First, remember, we have three types of emergencies. It is not that in all three types fundamental rights can be suspended. Only during national emergency, which was proclaimed under Article 352, fundamental rights can be suspended. That too, 2021 can never be suspended. Article 2021 can never be suspended. Okay, according to Article 359 of the Indian Constitution, even during national emergency, Article 20 and Article 21 can never be suspended. And according to Article 358, when national emergency was proclaimed on the basis of war or external aggression. See, remember, according to Article 352, national emergency can be proclaimed on three grounds: war, external aggression, armed rebellion. According to Article 358, only when national emergency was proclaimed on the grounds of war or external aggression, only on two grounds, Article 19 will be automatically suspended. Article 19 will be automatically suspended. And remaining some of the fundamental rights or all of the fundamental rights can be suspended by President's order. So, if you want to suspend fundamental rights apart from Article 19, because Article 19 will be automatically suspended. Apart from Article 19, if you want to suspend other fundamental rights, it is something like President's order is a must. But even through President's order, 2021 can never be suspended. Okay, and fundamental rights are inviolable. They are considered as sacred. If you see the fundamental rights and the constitutional setup of the country, you can tell the progress of the country and the nature of the political system they have, and also the rights, the basic things which the people enjoy there. Fundamental rights are so great, so inviolable, and fundamental rights should be protected. In fact, though our constitution guaranteed only few fundamental rights, our judiciary expanded it, almost made the fundamental rights chapter itself a very big constitutional setup for India. For a simple example, from Article 21 itself, hundreds of rights were drawn. The recent example being Puttaswamy versus Union of India, right to privacy is a fundamental right under Article 21, personal liberty. So the scope of fundamental rights and the ambit of fundamental rights is being expanded day by day. It is being expanded day by day. So these are the features of fundamental rights. Okay. These are the basic characteristics of fundamental rights. Next, Now we will discuss article by article. Article 12 to article 30 and 32. Up to 32 we will discuss article by article. Okay. And remember, all of you should try to remember at least the spirit of the article. It is highly difficult to replicate exactly the provisions of the article. At least the spirit of fundamental rights articles you should come with proper preparation. After 2-3 months, even in sleep, you should be able to speak about fundamental rights. That's very, very important. Not only as civil aspirants but also as citizens of India, you should know your fundamental rights. Okay, at least for that reason. And unfortunately, if a newcomer comes to me, if the parents insist me to test basic knowledge of the children, first I will ask how many fundamental rights we have. Very rarely students will answer this question. Very rarely students will answer that we have 6 fundamental rights. And one student told 32 fundamental rights. Don't laugh, even our knowledge is like that while coming to the preparation, right? Okay, mana paristhiti kuda alane undi kada, pakkollu enduku anukodam. Coming back. See, article 12 to 35 fundamental rights, 36 to 51 directive principles. Article 12 to 35 fundamental rights, 36 to 51 directive principles. Article 12, the first article of fundamental rights chapter. Article 36, the first article of directive principles chapter. Both the first articles 12 and 36 defines state. Defines state, S-T-A-T-E. First of all, why the first article of fundamental rights chapter and the first article of directive principles chapter defines state? The reason is, it is the obligation of the state to protect the fundamental rights of the citizen. If a fundamental right is violated, you can file a petition against the state. In the same way, it is the obligation of the state to enforce directive principles, though not legally enforceable, but state has to follow this. So for that reason, even in directive principles, you should have the definition of state. So article 12, article 36, definition of state. Definition of state. Now, article 12 says, it is, I am duplicating from the constitution text. See, all fundamental rights articles, when I am studying, when I am like you, I hope, mugged up. So you need not see the textbook. After going to the house, you can see the textbook, what I have discussed. Article 12 says, in this part, unless the constitution otherwise requires. The word state includes government and parliament of India, government and legislatures of the states, and all local authorities or other authorities within the territory of India are under the control of government of India. I am repeating, kindly try to understand. In this part, unless the context otherwise requires, that means in this part the state means government and parliament of India, government and legislatures of the states, and all local authorities or other authorities within the territory of India are under the control of government of India. First of all, we are very clear about government and parliament of India. Central government means postal, railways, defence, all these things. And you know the parliament of India. And we are also clear about government and state legislatures. State government, police, public health, irrigation, electricity, all these things. And state legislatures, you know. Local bodies, that also we are clear, like panchayats, municipalities, all those things. Whereas, there is a word called other authorities. There is a word called other authorities. There is a lot of confusion about this word, other authorities. Okay. Initially, the judiciary used to give very narrow interpretation. Initially give very narrow interpretation to the word other authorities. In fact, in the early days, the court used to say even the university is not the state, even some of the important public sector undertakings are not state. Court used to strictly follow ejus dem generis rule, EJUSDEM space GENERIS. Court used to follow a rule called ejus dem generis. Ejus dem generis means exactly same nature, ditto to ditto, exactly the functions of the state. So, court used to give very restrictive interpretation, very narrow interpretation to the word state in the beginning. Other authorities was very confined. Now tell me, if the definition of state has a very narrow interpretation, if the definition of state in the fundamental rights chapter or directive principles chapter has a very narrow interpretation, who will get affected? Who will get affected? Individual. You know why? See, if the definition of the state is wider, if many institutions come under the domain of state, individual can protect his rights against many institutions. Whereas, if the definition of state is very narrow, very few institutions come under state, people cannot file a case against that institution and get their fundamental rights protected, because you can file a writ petition against the state if your fundamental right is violated. When a private organization violates your fundamental right, you cannot directly file a writ petition against that organization. For example, I will give a small example. There is a very famous case called Air India versus Nargesh Mirza. Very famous case called Air India versus Nargesh Mirza. NARGESH space MIRZA. Air India versus Nargesh Mirza. This case comes in two important places. One is state, article 12, second is equality, article 14. Article 14, 15 in all these articles. You would have travelled in private airlines like Indigo, SpiceJet, Vistara, where you will be seeing air hostesses who are very young. If you travel in Air India, you see the crew who are little bit aged, who are beyond 35-40 years sometimes. How could this happen in Air India? How could not this happen in private airlines? The reason is, in this case, the female crew working in the Air India who are being discriminated because of various rules about their age. They have to retire once they get into 35 years. They have to take permission for marriage, or they have to take special sanctions and sometimes retirement, compulsory retirement during their pregnancy, all these things. Against all these rules, they went to Supreme Court. They went up to court asking that, see, men and women are same, and why different rules for male crew and different rules for female crew? And Supreme Court said this was a discrimination and everybody should be treated equally. So for that reason, Air India, if you observe, we have right to equality for women also. Whereas if you see private airlines, the fundamental right of women to be treated equally cannot be enforced, and women will be asked to retire when they get certain age. Okay, that cannot happen with the states. And one more example I will tell you. IPS. In IPS, you all know that if a man has to, if a boy wanted to become IPS, he should have minimum 165 centimeters height. If a female want to become IPS, there will be a relaxation. You know why? By nature, females are shorter than men. So in IPS, because it's a state, if it's a state, the government relaxes the norms, and you cannot file a petitions against private entity. For example, a software company is not helping women in getting proper employment. You cannot ask the software company by filing a writ petition to do what you want. But state has to protect fundamental rights at any cost. And you may get a doubt, untouchability is mostly practiced by private individuals or institutions. How can Article 17, which deals with untouchability, is available against state? It's a duty of the state to stop practices and protect people against untouchability. For example, if untouchability practice goes on, police or some other mechanism, state institution or instrumentality should help the individual. If they don't help, it's a failure of the state. So, you can file a petition against the state. If A practiced untouchability against you, you cannot file a writ petition against A. You have to file writ petition against state because state has the duty to protect your fundamental rights. So, for that reason, if fundamental rights are wide, if the scope of state is wider, who will be helped? Who will get the maximum help? Individual. Many institutions will come under the definition of state. Understood? So, the scope of the definition should be wider for the state. Then more rights of the individuals will be protected. Earlier, initial days, court used to follow a simple rule, literally exactly ejus dem generis rule. But slowly, states started expanding the domain of, the judiciary started expanding the domain of definition of state. But just by reading a name, you cannot say it is a state. For example, in a case called Tekraj Vasandi case, there was a definition. Say a society registered in the Societies Registration Act. Just with the fact that there was a society registered under Societies Registration Act, you cannot call it as a state. Just by reading a name, you cannot call it as a state. For example, we have started an institution called Institute for Constitutional Studies. Just by seeing the name, you cannot call it as a state. And finally, this is a very big debate. Even BCCI, Board of Cricket Control, is not a state. According to the case G Telefilms versus Union of India, BCCI is not a state. Simple thing I should tell you here, there is a case called Ajay Hasia versus Khalid Muzib. There is a case called Ajay Hasia, AJAY, Ajay HASIA versus Khalid Muzib, KHLID, Khalid Muzib, MUJIB. Ajay Hasia versus Khalid Muzib. In this case, the judiciary have given some guidelines how to consider a particular institution as state. And the judiciary said, and the court said, if the entire share capital of the institution is funded by the state, funded by the government, if the entire share capital of the institution is funded by the government, or if the institution is substantially funded by the government, or if it enjoys monopoly of status which is protected or conferred by the state. If it enjoys monopoly of status which is conferred or protected by the state. Monopoly of status in the sense, only that particular institution performs that functions. That's called monopoly. If the state gives monopoly, for example, I will explain you what is monopoly. You know UIDAI, UDAI. It gives Aadhaar cards. It's the only authority which provides us Aadhaar cards. Even before passing of Aadhaar Act, we can consider UDAI as a state because it is a monopoly authority to give Aadhaar card. Okay, that's called monopoly. And the institution have monopoly of status conferred by the state. Or if the institution performs very good substantial public functions, and sometimes by disinvestment there is a lot of privatization through public, there was a PSU, public sector undertaking, but with privatization we have disinvested in that, but still that PSU is performing public functions, even that is called state. So this is a test applied, and when you say that it is a state, you can file a writ petition against the state. And now you will get it out. Each judiciary comes under the definition of state. Okay. So can you file writ petition against judiciary? See, judiciary have two wings, administrative and judicial. With respect to appointments, promotions, etc., 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 in the lower levels, in all these things, you can call it as a state and you can file a writ. Whereas judiciary, while delivering judgments, you cannot say judiciary, we cannot exactly file a petition on it in the similar way how we can do against a state authority. Okay, judiciary, while performing administrative functions, we can consider it exactly like a state. Judiciary, while delivering judgments, we cannot further go for infructuous or repetitive petitions by saying that judiciary also we can file a writ petition on the judge or delivery of judgment. I think you got it now. Okay. So this is Article 12 definition of state. So other authorities means earlier narrow interpretation, now wider interpretation. Ajay Hasiya versus Khalid Muzid, substantial funding of the state or entire funding of the state, monopoly of the status or public importance, or PSU disinvestment, PSU still performs public functions, public sector undertaking still performs public functions. All these things comes under state. This is Article 12. Article 13. Article 13 speaks about law, L-A-W. Article 13 speaks about law. Now try to understand. I told you in the beginning, if fundamental rights are taken away, we can go to court. For example, if a parliament makes a law or constitutional amendment which is against fundamental rights, court can declare as null and void. Okay, void means it is not valid. First you should know, Parliament shall not make any law which is inconsistent with fundamental rights. If Parliament makes any law which is inconsistent with fundamental rights, it is void. Void means not valid. Void means not valid. But you should get a doubt here. Majority of the laws which we have even today, for example, take IPC, Indian Penal Code. It was passed in 1860. Indian Evidence Act 1872. Majority of the laws which we have today are pre-constitutional laws. The laws which have come before the constitution. And fundamental rights were guaranteed only in our constitution, which came into force on January 26, 1950. What about the laws which are against fundamental rights, which are made before the commencement of the constitution? So the Article 13 says that even the laws, even the pre-constitutional laws, to the extent of inconsistency with the fundamental rights chapter, they are also not valid. To the extent they are contradicting with the fundamental rights chapter, even that are not valid. Even those are not valid. Am I clear? So now from Article 13 there are three important doctrines. From Article 13 there are three important doctrines. One is doctrine of judicial review. Doctrine of judicial review. The word judicial review is not mentioned in Article 13, but Article 13 gives the power of judicial review to the judiciary, which we have borrowed from American Constitution. The power of judiciary to verify the constitutional validity of any law made by the Indian Parliament. If judiciary finds that the law is contravening the provisions of the Constitution, judiciary can struck down the law. Judiciary can struck down the law. This provision is called judicial review. We have borrowed this idea from American Constitution. In America, in the first case called Marbury versus Madison, M-A-R-B-U-R-Y versus M-A-D-I-S-O-N. In America, the first case called Marbury versus Madison, the power of judicial review was spoken out. Okay. And in India, in Minerva Mills versus Union of India 1980, in India, In Minerva Mills versus Union of India 1980, it was said that judicial review is a basic feature of Indian Constitution. Judicial review is the basic feature of Indian Constitution. That means you cannot take away judicial review. This is first doctrine, judicial review. The second doctrine is doctrine of eclipse, ECLIPSE. The second doctrine is doctrine of eclipse. What do you mean by doctrine of eclipse? See, if a law is against fundamental rights, a question comes. If a law is against fundamental right, a question comes. Is the law totally invalid, totally struck down, torn into pieces and thrown in the dustbin, or the law will be dormant? The law will be dormant. Dormant means eclipsed. You all know eclipse, right? Whether the law is under cover. Now the question is, according to the experts who believe in doctrine of eclipse, according to the experts who believe in doctrine of eclipse, the law which is against fundamental rights is not totally dead. It will be under dormant condition. It will be under slumbering, sleeping condition. Whenever the law is required, we can again open up. I will give a small example. I told you some fundamental rights are not available to non-citizens. When you struck down the law completely which is against fundamental right, what about some non-citizens who do not have certain fundamental rights? So then the law should be applicable to them. I am explaining again. According to doctrine of eclipse, the law against fundamental rights is not completely void. It will be under slumbering stage or dormant stage. It will be under slumbering stage or dormant stage. Why? Small example. Some fundamental rights are not available to foreigners. A law which is against fundamental rights is if it is completely dead. When the issue of foreigner comes, there should be some law to regulate them who do not enjoy certain fundamental rights in India. So at that time we should open up this law. So experts say fundamental rights which are against, the laws which are against fundamental rights should be under the dormant stage. Okay, this is only theory. This is called doctrine of eclipse. We have one more doctrine under Article 13 called doctrine of severability. Severability. We have one more doctrine called doctrine of severability. Doctrine of severability or doctrine of separatability. Doctrine of severability or doctrine of separatability. What is this? This is actually, say there is a law. Some provisions of the law are against fundamental rights. Some provisions of the law are against basic constitutional principles. Is the law entirety, in entirety, or is the total law should be thrown out, or only a part of law should be struck down? Okay. Again I am explaining, kindly listen. There is a law which is against fundamental rights. The entire law is not against fundamental rights. Only some provisions of law is against fundamental rights. Only some provisions. Now the question is the entire law thrown out or only provisions of law should be cut down? So the experts have devised a mechanism called doctrine of severability. The court can apply this doctrine. It says, if you can remove the contravening provisions, if you can remove the bad provisions successfully without defeating the objectivity of the entire law. For example, every law is made for a purpose. If you can cut down the few provisions which are against fundamental rights, even after cutting it down, even after deleting, if the law serves its purpose, if the law supports its purpose, then delete the contravening provisions and keep the law intact. This is called blue pencil rule, also called as blue pencil rule. That says, if you can remove some provisions, still if the remaining law can serve its purpose, then keep the law intact, only remove some contravening provisions. 6 fundamental rights. First right, right to equality. Right to equality. Article 14 to Article 18 of the Indian Constitution deals with right to equality. Article 14 to Article 18 of the Indian Constitution deals with right to equality. Article 14 says that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. Article 14 says that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. The word equality before law is of British origin. The word equal protection of law is of American origin. The word equality before law is of British origin. The word equal protection of laws is of American origin. Though we follow the spirit of rule of law, the word rule of law do not find its place in the Indian Constitution. Rule of law is inherently mentioned. Rule of law is inherently mentioned in Article 14 itself. The word rule of law is of British origin, which was given by A.V. Dicey, D-I-C-E-Y. Be you ever so high, the law is above you. And rule of law implies from Prime Minister to common man, the law is equally applicable to everyone. From Prime Minister to common man, the law is equally applicable to everyone. Equality does not mean absolute equality. By nature, men are not equal. Absolute equality can never be expected. Equality means equal treatment in equal circumstances. Equal treatment in unequal circumstances will amount to inequality. What we need is equal treatment in equal circumstances, unequal treatment in unequal circumstances. That is called equality. For example, if a father have two sons, if one son can walk, other son cannot walk, he cannot ask both the sons to go on bicycle to the school. He should specially protect the person who cannot walk. That does not mean that he is deviating from the principle of equality, because by nature some people need to have special protection. Might be through historical injustice, might be with natural problems. We need to specially protect someone. That does not mean you can discriminate anyone. Unequal treatment in unequal circumstances does not mean discrimination. Discrimination is based on arbitrariness. Just because somebody's hair is grey in color, I cannot favor, or somebody's skin is red in color or white in color, I cannot give special protection to them. But as a group, when a person is deprived, I can help. So discrimination can be in favor of someone so that I can help the group to come up in the society. But that discrimination should be fair and reasonable. It should not be arbitrary or artificial. For example, if I am a Prime Minister of India, just because I like Mr. A, I cannot make him a civil servant without passing the exam. This is called arbitrariness. But if I am a Prime Minister of India, I can say that if in India there are general category people who are really academically backward, I wanted to give 10% reservation to them, I can do that. But just because I like Mr. A, I cannot bypass the entire process, I cannot make him an IAS officer. So you can discriminate, but it should be based on some reason. It should not be arbitrary or artificial. It should not be, it should be just and fair. Just, fair and equitable. This is Article 14. And I wish to tell you a small example. We have first IPS officer, you know, Kiran Bedi. We also have first Indian Foreign Service officer, lady. She is CB Muttamma. Her name was CB Muttamma. When she got selected as the first woman Foreign Service officer, the Foreign Service rules with respect to females are very, very discriminatory. She went to Supreme Court. By the time the court delivered the judgment, the ministry have taken away the rules which are against the principle of equality. So for males there are different rules, for females there are different rules at that time. But equality is a fundamental right. Equality is a fundamental right. In the same way, if men are allowed to go to Sabarimala temple, women should also be allowed. Women can be discriminated, can be disallowed, but there should be a reason. The reason should have a logic. The logic should be just and fair. Okay, this is Article 14. Article 15, prohibition of discrimination. Article 15 is basically prohibition of discrimination. The state shall not discriminate any citizen. Any citizen, here Article 15 there is a word called citizen. Based on religion, race, caste, sex, place of birth or any of them. Based on their religion, caste, sex, place of birth, one cannot be discriminated. Entering into shops, restaurants, bathing ghats are places of public importance. According to Article 15, Clause 3, special provisions can be made for women and children. You can give special provision for women and children. I will give a small example. When you have boarded RTC bus, you will see seats reserved for women. You cannot ask why seats are not reserved for men. Okay. In the same way, Domestic Violence Act. There is a Domestic Violence Act supporting women, but there is no Domestic Violence Act favoring men. Recently we have a campaign, Men Too. Women to Me Too campaign, now Men Too campaign. You know that. So coming back again, special provisions can be made for women. Even the laws can be helpful for women, but not for men. And Dowry Provision Act, helpful for women. In the same way, children. You know, midday meal scheme is for children. Anganwadi schools for children. Special protection can be made given for women and children. The reason is they are naturally weak. So, in order to uplift them, special protection can be given. Initially in Article 15, there are only 3 clauses. Initially in Article 15, there are only 3 clauses. But there is one thing that is really interesting. Champakam Dorairajan versus State of Madras. Champakam Dorairajan versus State of Madras, or State of Madras versus Champakam Dorairajan. Very famous case which led to the amendment, first amendment which added 15 clause 4 to the constitution. Clause 4 to Article 15. What is this Champakam Dorairajan versus State of Madras? Madras state government during 1950s have given reservations for SCs and STs in medical and engineering colleges. In medical and engineering colleges, Madras government gave reservations. Till that time, many engineering medical seats, including civil services at that time, there is one community, Brahmin community in Madras, they used to occupy. In fact, they are learned people. In order to promote social justice, Madras state government have given reservations for SCs and STs. One lady, Champakam, she went up to Supreme Court saying that giving reservation is against right to equality. See, when right to equality is a fundamental right, how can you give reservation? When right to equality is a fundamental right, how can you give reservation? Then Madras state government argued in the Supreme Court that we have given our reservations to SCs and STs to promote social justice in accordance with Article 46 of the Indian Constitution. In accordance with Article 46. Article 46 says that state should promote educational and economic interests of scheduled caste, scheduled tribes and other backward classes of citizens. But Supreme Court said Article 14 is a fundamental right, Article 46 is a directive principle. Fundamental rights are enforceable in court of law and directive principles are not enforceable in court of law. Fundamental rights are enforceable in court of law and directive principles are not enforceable in court of law. And Supreme Court said directive principles are subsidiary to fundamental rights. They are secondary to fundamental rights. And when there is a conflict between right to equality and SC/ST reservation 14 and 46, Supreme Court said equality is more important and Supreme Court struck down the reservation law made by Madras government. This came as a shock to the Parliament. Then immediately Parliament made first amendment and added clause 4 to Article 15 saying that special provisions can be made for socially and educationally backward class of citizens. Special provisions can be made for socially and educationally backward classes of citizens. Okay, Article 15 clause 4 was added and special provisions can be made for socially and educationally backward class of citizens. So, reservations are not exceptions to equality. By clause 4, Parliament have made reservations are the part of equality. In order to promote an equal society, we need reservation. But whether reservations are going to the needy people or not is a different discussion. But as such, as a civil aspirant, you cannot say that reservations as such are bad. Okay, reservations are a part of equality to promote equality. By clause 4 to Article 15, the Supreme Court, the Parliament have done this. The Parliament have done this. This is a famous case, Champakum Durarajan versus State of Madras. Whenever you are writing an answer in Article 15, you have to quote Champakum Durarajan. Because of Champakum Durarajan judgment, clause 4 was added to Article 15. Champakum Durarajan have a far-reaching consequence where the Parliament have added clause 4 to Article 15 after this judgment. Okay, so the issue of reservations was solved at that time. Article 16 of the Indian Constitution, which is the most debatable and the biggest issue today in the Constitution. Article 16, equality of opportunity in public employment. Article 16, equality of opportunity in public employment. In matters of public employment, there will be an equality of opportunity. It's not equality to public employment or right to public employment. We don't have right to become IAS. We have the right to have access to civil's exam. So no citizen shall be discriminated based on religion, race, caste, sex, place of birth to public employment, to access to public employment. But there can be residence qualification or some qualifications required for the post. Now we should understand. Leave away political reservations. Political reservations are in accordance with Article 330, 332. 330 for Lok Sabha, 332 for state assemblies. Leave. Political reservations are different. Reservations in education and employment now we are discussing. From the beginning, we are giving SC/ST reservations. Reservation for SCs and STs after 15 clause 4. And the thing is, there is no reservation at the central level for OBCs, other backward castes. In the state level, we used to give them reservations. Some of the states, not every state. and central level there are no reservations. And the concept of reservations for BCs started even in the early times. It got into 4, it came into 4 by 1970s and 1978 in that area here. Finally, to study about the conditions of backward castes and whether they need reservations or not, all these things. Earlier there was Kaka Kalelkar Commission, later Mandal Commission was appointed. Mandal Commission gave recommendations based on which more than 3000 castes should be included in the backward castes. After Mandal report, there is a lot of furor in the country. Some of them supporting reservations, some of them not supporting reservations. And the issue went up to Supreme Court, which is called Mandal case. The real title of the case is Indra Sahane versus Union of India. Indra Sahane versus Union of India, also called as Mandal case. This judgment is very, very important. There are 9 judges in this case, constitutional bench. The Supreme Court in this case said giving 27% reservations for OBCs is correct. Giving 27% reservations for OBCs is correct. But creamy layer in the OBC should be excluded. Creamy layer in the OBC should be excluded. Because, see, in SC/ST category, we don't have creamy layer concept. In OBC category, we have creamy layer concept. Though you are the richest person in SC/ST category or you are a topmost officer, still you will get the reservation. The reason is that discrimination in SC/ST category is considered as social. The discrimination in OBC category is generally economic. SC/ST category social discrimination and OBC category economic discrimination. So Mandal Commission, that is the Mandal Commission judgment, Indra Sahane case, the Supreme Court said being SC/ST itself is a qualifiable mark for reservation. You need not go with their economic status. Whereas for OBCs, creamy layer concept, the OBCs who have come up, they should not ask for reservations. Okay, and in the Indra Sahane case, that is Mandal Commission case, they also said reservation should not exceed 50%. Reservation should not exceed 50%. And this case is a landmark judgment, and central government started giving OBC reservations also. And here you should understand 2-3 points. Some states exceeded 50%. For example, Tamil Nadu. Reservations went up to 69% in Tamil Nadu. And you know what happened? Tamil Nadu government influenced the central government and got 76th Constitutional Amendment Act to be passed, and through that the reservations in Tamil Nadu were kept in the 9th schedule. And 9th schedule deals with land reforms basically, but the items which are mentioned in the 9th schedule cannot be questioned in the court of law. But the Supreme Court in IR Coelho versus Union of India, in IR Coelho case, COELHO, IR Coelho case, the Supreme Court said there is no blanket immunity on all items which are mentioned in the 9th schedule. Just because you have mentioned in the 9th schedule, that does not mean that there is a blanket immunity for that. That does not mean that you cannot question it in the court of law. So tomorrow you can make some drastic constitutional amendment, and tomorrow if you keep that in the 9th schedule, that does not mean that you cannot make it as under review. You cannot review it. So this has happened. So Indra Sahane versus Union of India, Mandal Commission case, it was said that reservation should not exceed 50%. And after that, in the year 2006, a landmark judgment have come called Nagaraj case. A landmark judgment have come called Nagaraj case. In this Nagaraj case, 5 constitutional bench said you can give SC/ST reservations even in promotions, but The backwardness should be proved with quantifiable data. The backwardness of that community should be proved with quantifiable data. But recently, last week, in a case with respect to Karnataka reservations, the Supreme Court said giving reservations for SCs and STs even in promotions with consequential seniority is not against the Constitution. We can give SC/ST reservations in promotions also with consequential seniority to bring up the SC/ST communities to the mainstream. So this debate is an unending debate with lot of cases being filed with respect to reservations. Article 16. In Article 16, one has to remember many constitutional amendments, which I will give a hint now. 77th Constitutional Amendment, 81st Constitutional Amendment, 82nd Constitutional Amendment, 85th Constitutional Amendment. 77th Constitutional Amendment, 81st Constitutional Amendment, 82nd Constitutional Amendment and 85th Constitutional Amendment. In the 77th Constitutional Amendment, reservation in promotions was mentioned. Reservations in promotions. Not only in the initial recruitment, even in promotions you can give reservations. That is 77th. 81st Amendment, this deals with carry forward. If a sufficient number of members do not get qualifying mark in that community in the particular year, there can be, the post can be carried forward. That's called carry forward. 81st Amendment. 82nd Amendment added a proviso to Article 335 of Indian Constitution. 82nd Constitutional Amendment Act added a proviso to Article 335 of Indian Constitution. Article 335 says claims of SCs and STs. Claims of SCs and STs can be considered, but administrative efficiency and merit cannot be compromised. Claims of SCs and STs can be considered, but administrative efficiency and merit cannot be compromised. In that there is a proviso. The proviso says nothing in Article 335 will make the Parliament or the authorities executive to relax minimum qualifying mark for SCs and STs. That means Article 335 will not disallow. That means Article 335 is not saying that minimum qualifying marks cannot be reduced. In case of claims of SCs and STs, you can even reduce the minimum qualifying mark. That is 82nd Amendment. So you can even reduce qualifying mark for SCs and STs. Okay, and 85th Constitutional Amendment Act speaks about consequential seniority. Consequential seniority in the sense, when you are getting reservation in promotions, not only in the inception stage, in the consequential seniority at every stage you will be senior. This is called consequential seniority. So with respect to Article 16 and reservations, 77th Amendment, 81st Amendment, 82nd Amendment, 85th Amendment, all the four amendments are important for you to remember. This is Article 16. Article 17, abolition of untouchability. Article 17, abolition of untouchability. The practice of untouchability is prohibited. The practice of untouchability is prohibited. Okay.